The writ jurisdiction as under judicial review, the first category of instrumentalities which against whom this jurisdiction is available is state and the local authorities and other authorities, so also the judiciary and other persons. So when it is against state, such jurisdiction is available, and as it is defined under Article 12 in Part 3 of the Constitution, which contains the fundamental rights from Article 12 to 35, the state exactly here means the union legislature, union executive, the state legislature, and the state executive and local authorities and other authorities, also the judiciary. So when it is regarding the union legislature or union executive, it means the government of India, which is known as union executive, and the Parliament of India, which is the union legislature, and regarding the state of a particular unit of the Indian Federation, it includes the very government of each state as state executive and the state legislature as the legislatures of each state. So also local and other authorities within the territory of India are under the control of the government of India are also falling under the writ jurisdiction as provided under Article 32 of the Constitution, and as regarding local authority, as it is being defined under subsection 31 of section 3 of the General Clauses Act 1897, local authorities shall mean a municipal committee, district board, body of commissioner or other authority legally entitled to or entrusted by the government within the control or management of a municipal or local fund. So, according to entry 5 of list 2 of 7 schedule, local government includes municipal corporation, improvement trust, district boards, mining settlement authorities, and other local authorities for the purpose of local self government or village administration. Village panchayat is also included within the very meaning of the term local authorities. And as regarding other authorities, there is much controversy as to the meaning and the import of the term other authorities. And as regarding that, the Supreme Court has held that the term other authorities include all the authorities created by the Constitution or statute and on whom powers are conferred by law, whether or not they are engaged in performing governmental or sovereign functions. Thus, it is almost settled that the constitutional or statutory authorities on whom powers have been conferred by law or include within the meaning of the term other authorities. The statutory bodies like Oil and Natural Gas Commission, Life Insurance Corporation, Industrial Finance Corporation, and International Airport Authority, Electricity Board, the Damodar Valley Corporation, etc., are included within the meaning of the term other authorities as under Article 12. A university established by statute is also included within the meaning of other authorities. So, the Supreme Court has taken the different view and interpreted the term other authorities more liberally in subsequent time, and the company incorporated under the Companies Act and the societies registered under the Societies Registration Act have been held to be included within the meaning of the term other authorities as in Article 12. The present position appears to be this, that the body, whether statutory body or non-statutory body, will be included within the meaning of the term authorities in Article 12 if it is an agency or instrumentality of the government. So, in the leading case, M.K. Agarwal versus Gurgaon Grameen Bank, in 1988, the Supreme Court has held that Gurgaon Grameen Bank, constituted under the Regional Rural Bank Act in 1976, having regard to its constitution and nature of its legal entity and measure of state control, is an instrumentality of the state and therefore state for the purposes of Article 12. It is to be noted that even a private body or a corporation or an aided private school may be included within the meaning of other authorities and thus may be state for the purposes of Article 12 if it acts as an agency or instrumentality of the government. So, whether there is financial assistance given by the state, and if so, what is the magnitude of such assistance, whether there is any other form of assistance given by the state, and if so, whether it is of usual kind or it is extraordinary, whether there is any control of the management and policies of the corporation by the state, and what is the nature and extent of such control, whether the corporation enjoys state conferred or state protected monopoly status, and whether the functions carried out by the corporation are public functions closely related to government functions or governmental functions, will determine the very nature of local authorities, which are also falling under other authorities as being defined under Article 12 of the Constitution. And now another part is that whether the judiciary is a state. The present position appears to be this, that when the judiciary acts in its judicial capacity, it is not included within the meaning of the term other authorities, and therefore it is not state under Article 12, but when it acts in administrative capacity, it is included within the meaning of the term other authorities, and therefore it is state. The decision of judgment of the courts cannot be challenged on the ground that they violate the fundamental rights, whether or not the judgment of the court suffer from any infirmity can be decided only in appeal. However, if the judiciary acts in administrative capacity or exercises administrative functions to make rules, and its actions or rules contravene fundamental rights, they may be challenged in the court. Thus, if the rules made by the Supreme Court or High Court contravene the fundamental rights, they may be challenged in the court. When the Chief Justice of a High Court or Supreme Court appoints officers of the court in the exercise of his power of appointment, and the appointments made by him contravene any fundamental right, they may be challenged in court, because when the Chief Justice of the Supreme Court or of a High Court makes an appointment in exercise of his power of appointment, he acts in administrative capacity, and therefore he is included within the meaning of the term state as it is defined under Article 12 of the Constitution. And in our upcoming video, we would like to discuss under certain circumstances how the very fundamental right guaranteed under Article 12 as also under Article 32 of the Constitution under judicial review can be suspended, and in all these cases of suspension, of the fundamental rights, what remedies are available as per the very provisions of Article 32 of the Constitution, which is called as containing judicial review.